Hi, this is Get the Legal Bay. I welcome you back to my channel. I hope I find you well. And now, if you find this content meaningful, you want to engage with me, please do like, follow, and subscribe, and drop a comment below. So let's talk about termination of pregnancy or abortion. This is something that has been very topical, not only in Africa, in Zimbabwe, but even in the world, in the United States of America, you name it, so many conversations around this. But I want to talk about where the standpoint is currently in terms of Zimbabwean law. So the law dictates that termination of pregnancy is unlawful. Several issues were raised around how sometimes the process takes too long. Was passed, but what has actually changed? I want to separate the noise from the fiction and break down what the law says. With the passing of the Medical Amendment Act, certain provisions have now been updated, but importantly, the core of the legislation remains restrictive. This is not a free access regime. It's still controlled. It's still a legally limited framework. So after the amendments, termination of pregnancy is still only permitted under specific conditions, where the pregnancy endangers the life of the mother, where there is serious risk to the mother's physical health, in cases of rape or incest, and where there is high risk of serious fetal abnormality. Now, these grounds remain the legal foundation. They have not been removed. Here's what the Medical Amendment Act actually improved. Procedural clarity, the streamlining of approval processes in lawful cases, reduced bureaucratic delays in accessing legal termination. Medical oversight has been strengthened. There are now clearer roles for registered medical practitioners, emphasis on procedures being conducted in designated institutions. There's also patient protection measures that have been reinforced with stronger safeguards for women accessing lawful services. There are more defined compliance requirements for healthcare providers. So in short, the law has become clearer and slightly more accessible, but not broader in scope. What did not make it into the bill? So there were some topical provisions where there was one provision where anyone, even a girl under the age of 18, could get an abortion or termination of pregnancy on request without consent of her mother or consent of any parents or guardian. Well, this was highly problematic with religious institutions, with members of the public. So this did not make it into the Amendment Act. So the on-request termination rights were refused. The full decriminalization of abortion was refused. The broad expansion through existing legal grounds was also refused. And it was a no to removal of procedural safeguards like approvals and certifications. These were considered controversial and ultimately excluded. So where does this leave us? The current legal position is termination of pregnancy is still a criminal offense. It falls within, unless it falls within legal exceptions. It must be carried out by a registered medical practitioner in an approved institution following prescribed legal procedures. Outside of this framework, both the provider and patient may face criminal liability. So, the Act has just been amended. This doesn't mean that abortion has been liberalized. It has been refined and not expanded. Understanding the law is not about opinions, it's about accuracy. And if you're navigating this space, know the limits, know the process, and stay within the law. This has been the Legal Bay. Let's take this conversation further. Drop me a comment in the comment box below. Like, follow, and subscribe for more content like this.